welcome to this special conversation. Across the entire country, the million-dollar question which is being raised is this. Have the investigating agencies such as the Director of Enforcement, popularly known as ED, have they gone completely rogue? Has the time come for us to relook at what the ED was meant for and what it's really doing? Why is it that suddenly there is a spate of bail which is being given by the topmost court of the country? With me, one of the foremost legal constitutional luminaries of our country, well-known legal mind, Aman Lekhi, with us today. Great pleasure to have you with us, Aman.
My pleasure. Thanks.
Let me begin first by asking you about the question which I'm raising. Has the time come for us to revisit the purpose of setting up of an agency like the Director of Enforcement?
Well, Bhupinder, the answer is slightly nuanced. You have the law, and then you have application of the law. And the misuse comes generally in the application, which is actually a misapplication. The issues which arise is because law is seen in the application and not in the enactment. There are certain safeguards in the enactment, in some way supplemented by the purpose of the enactment. So, it is conceived for a particular purpose, and it is presumed that in the application of the law, the inbuilt limitations would be followed. What we see today is use of the law inconsistent with the intent behind its enactment, where the application is in some way influenced by political strategy. Now, law is always a political weapon, but political in the sense it has element of power to it, and power is basically intrinsic to any governmental machinery. But when that power, intrinsic machinery, gets coupled with ideology, or for that matter political ideology, in that event it shifts away from the original understanding on which this law is based.
So let's settle this. What was the original understanding? Because initially, and I'm specifically looking at ED, and we'll come to the more contemporary issue now, ED was meant to be a body which would have dealt with cases of terrorism, financial terrorism. Then Mr. Chidambaram, the erstwhile UPA government, it suddenly became that the ED also had the powers to look at domestic cases of corruption. And today ED is in front of you everywhere. What was the purpose? What it has become? Is it consistent with law?
Well, enactments like these, there are two divergent views. One is, insofar as the scope of the law is concerned, it can have a narrow scope, limiting the number of offences to which it applies. It can have a broad scope, enlarging the offences to which it applies. In its original incarnation, because there was a gradation of offences, A, B, C, the penal aspects were limited to one category and did not apply to the other categories, and it was more or less equally populated across the categories. Now, what happened was that there was a shift from the categories which are less penal into the most penal category, that is from B to C, from B basically to A. As a consequence, this was the first movement away from the original intent, which limited the offences to which money laundering would apply, to basically apply to virtually all kinds of offences, so that you could actually apply money laundering to the most insignificant offences also. So that gave an opportunity to enlarge the application of the law. Now, once you have a bigger play field, then the options that I said in the beginning of the use of the law, the chances of the misuse of the law become more, because the options to exercise the power, which I just mentioned to you, the option to exercise the power under the law to aid a purpose not necessarily within the confines of the law become more manifest.
But you know, when I look at numbers, and government itself had last year come out with a statistic which was presented in Parliament, that the overall value of assets which have been confiscated by the Enforcement Directorate versus the overall value of assets which legally speaking the ED should really have kept within its custody. There's a massive difference. The number of cases which have been filed, but the conviction rate is being abysmally low. Is it a fault of the law? Is it a fault of application? Or is it that the courts have become, fair game for everyone?
Well, a bit of all three. As far as the law is concerned, its very nature makes it open to interpretation. That's why precision in what law says is absolutely imperative. And you can't ever have a perfect law. So, some element of imprecision is in every law. So, the first issue. Now, when that imprecision in law is coupled with the intent to misapply it, that is the application of the law, then the imperfections get magnified. The imperfections get magnified, so misuse becomes rampant. When the misuse becomes rampant, ease of application follows. When ease of application follows, numbers increase. When numbers increase, the consequences of the law being in operation consequentially increases. And when the law is in operation but is in misuse, it increases. Then the situation which you mentioned comes in, which is where the role of the courts come in. Now the courts at that point of time have to intervene. Now the court should intervene to halt the process where it is warranted, because there is a supreme law above a statutory law, and that's the constitution. Right. Now there are certain principles which are consecrated and inviolable and have necessarily to be the lodestars for the purposes of construing the statutory provisions. Now courts, and I am talking about constitutional courts, the constitutional courts, the High Court and the Supreme Court. And I refer to constitutional court because they got supervisory jurisdiction in the trial court. Not, and of course the trial court is of utmost significance as criminal law is concerned, but in a legal structure, a higher responsibility is given to the constitutional courts. Now there, I feel that the method and manner of interference was not optimum, because the principles which are violated in the circumstances which are more or less rampant, interference had to be immediate. And when the courts dither in interfering, then the check which is on the executive gets to that extent diluted.
So is that what's happening now in the Supreme Court when you're suddenly seeing a spate of bails being given? And what's the argument being given? The argument being given is, in Justice Gavai's court, that because trial cannot start, and there is a delay in trial, so right to liberty question now comes into play. How do you look at this? Right to liberty versus someone being incarcerated for long.
See, at the basic level, it's correct. But I have my reservations about the manner in which it's expressed. Because I feel, and this is my personal opinion, this is an institutional response, in this case by the judiciary, to what is perceived as some element of executive excess, because there is a co-equal organ. You got the judiciary, you got the legislature, you got the executive. As far as the policing is concerned, prosecution is concerned, the executive, and then you have as the check the judiciary, which is the upholder of the law. Now ideally, the judiciary should respond legally. What I feel here is this sentiment, and that sentiment, to a large extent, because I am talking from the point of view of the common man, does not clearly enunciate the law, and I'll explain why. You have these judgments which are there, which say that, see, 21 is there, you have to construe PMLA consistent with 21, so you cannot in any way disregard liberty. There is a presumption of innocence, because the presumption of innocence and a guarantee of liberty. A provision like section 45 cannot in any way mandate excessive pre-trial detention, because presumption is there and you can't possibly. And it invokes the principle of expeditious trial and says that you cannot keep a person in custody indefinitely. The question here is, and that is where I personally feel the Supreme Court ought to have answered and has not, when is this principle of speedy trial violated? And I'll explain why. Because all of us are not celebrities.
We can't reach the Supreme Court.
No, even if we reach the Supreme Court, it's not necessary that the kind of attention which politically significant matters, which have got a pan-India ramification, or obviously have a greater element of deference where the Supreme Court is concerned because of the sheer nature of the controversy, which is very different from an individual controversy. So, in the very nature of things, we stand at a disadvantage because the courts will not, in that situation, be alive to this particular requirement. Now, that is what I am pointing out. Now, look at all these laws. In Sisodia is inside for about 14 months. Kavita, which follows Sisodia, it was 5 months. Right? Chidambaram, right, which strangely, Supreme Court did not deal with 45 in that case, was 45 days. Right? And in reliance in the judgment relied upon in Sisodia, the judgment where the court granted the bail was 4 years. Now, when is speedy trial violated? On 45 days, 5 months, 1.5 years, 4 years.
So, has the time come, therefore, let me ask you, how do you legally quantify what is the stage of a speedy trial from detention?
Now, that's what I'm saying. Now, why am I saying? The question is, this was an institutional response that enough. You cannot continue like this, right? We could not continue like this because there has to be a limit to which you will apply the law in a manner which is not warranted. And what the peculiar aspect of these cases is, in one judgment, the law officer appearing says, don't deal with the matter on merits. Now, no law officer should ever say, don't deal with the matter on merit. That means that's an admission of the fact that there's some issue where that. In another case, it was said that, no, we will conclude the trial we will conclude the investigation 8 months. But assumption being started again. Anyway, those are aside, we are not concerned with that. Ideally, what should have happened is, I personally feel, so that an ordinary Indian is secure. Ideally, what should the Supreme Court, there's a history to bail. It begins with the Bill of Rights, goes to Magna Carta, there's a whole history. The history of English law culminates in the 8th Amendment of the US Constitution and a few, ideally, what should this was an ideal opportunity for the Supreme Court to enunciate clearly that particular history, bring in the principles relating to the 8th Amendment and specifically deal with the provision like 45. Because it is not, where law generally is concerned, it is not as if pre-trial detention is always wrong. So I don't agree that bail not jail is inapplicable to statutes like 45, and the Supreme Court itself classified these separately. It behoved the Supreme Court to deal with it directly and yet say, notwithstanding it being a separate class, we will still grant bail. That behoved the Supreme Court because that placed it on a surer footing. That this is there which the Supreme Court did not do. But that apart, what is necessary is, what the Supreme Court has said, unless there is a compelling interest, right, to warrant a continued detention, a provision like 45 cannot be invoked in the absence of a clear finding of any interest of vital importance of the country being imperiled.
Tell me one thing, Aman, don't you think that the way 45 is being used, when it comes to the question of bail, the triple test, how can, without a trial, how can a judge, for instance, come to this conviction whether prima facie a person is guilty of having committed an offence or not? Whether an offence has been committed or not should be post-trial. Here you want the judge to be convinced whether this offence has been committed at the first stage itself. Is there no contradiction here?
No, of course, there's a contradiction. See, this is kind of a hybrid kind of provision. There's a concept called preliminary hearing. This is in some various jurisdictions. Now, preliminary hearing is basically to find probable cause. Now, probable cause along with a reasonable satisfaction with the person being guilty. Those are the preliminary hearings which normally take place when you decide whether to proceed with the case or not. Now, this lifts up elements of preliminary hearing, which goes to the necessity of trial, right, and implants it in a provision for bail, which is not strictly speaking something which happens in the course of the trial, which is in some way collaterally related to a proposed trial. That's what I'm saying. What the Supreme Court, what was necessary for the Supreme Court to do was to examine conceptually a provision like 45, put it in the context of what would have been a legitimate mechanism to deal with it, and then say that as far as the requirements of 45 are concerned, in this system which avails, cannot possibly be satisfied, which the Supreme Court does not do. Now, what is very important here is, the Supreme Court has accept in these judgments said that a prima facie, we are agreeing with the fact that prima facie case is there. Right? They don't contest it. They don't interfere with the finding of a prima facie case. But they say that notwithstanding a prima facie case, that on the ground of delay,
they should be given bail.
They have to be given a bail. Now, which again begs the question, what is the delay? And then invites a further criticism that how do you deal with the provision which makes the merits of the case a necessary requirement before you grant bail?
You know, because I'm seeing on the 9th of August, while granting bail to Manish Sisodia, the Supreme Court had held that the stringent twin conditions to granting bail can be relaxed if the accused has undergone a long period of incarceration. Now, let me give you the example of the present Jharkhand Chief Minister, who also went to jail in a so-called money laundering case, spending 6 months in jail, comes out where the court says that actually there is no case of money laundering. There is no incarceration. The court says there is no case of money laundering, but the guy has been in jail for 6 months. How do you reconcile these two cases? Where on one hand, Supreme Court says you can relax it if you're sure. So are we talking about some notion of credibility of an individual that we're dealing with, and the Supreme Court will decide who's more credible, who's less credible?
First of all, what is a long period of incarceration? There has to be some.
Is there a legal definition?
No. There has to be some standard on which we can satisfy the test. What is the worth of a law? Is its incertainty and predictability, right? Now, when the long period of incarceration is itself left indefinite, you leave it to the discretion of the court in a particular case to grant or not to grant bail. So we are more or less, notwithstanding there being individual orders, right? We are more or less the same situation which we were prior to the grant of the order, which brings me to the question, how do we deal with conceptually? What would be necessary? And that's the reason why I said it is sentiment, not law. And as far as where common man is concerned, there is a more assured support for a common man in law than sentiment, which is always unpredictable and unreliable. You know, today the sentiment is favorable, tomorrow the sentiment may not be so. We cannot rely upon sentiment for our liberty. We have to ground liberty in law.
Are you suggesting that sentiment is a necessary byproduct of a political environment which may exist within a society?
Sentiment is present in every political environment. The question is, should it be sentiment alone, or it should be sentiment and law, with law being dominant, the motivating force in applying the law being sentiment. But sentiment by itself cannot masquerade as a law or substitute the law.
So how is it that sentiment is only playing itself out when it comes to the Supreme Court, but not at the High Court, not at the trial court?
No, I'm not saying. Now,
why are bails being given?
No, I'll explain.
Is the Supreme Court therefore trying to correct that anomaly?
Yes. Please. Which brings me to what I said at the beginning. Law and application. Application, abuse in the sense of political strategy moved by ideology. Now, we are in an environment, and all of us are political actors, whether we like it or not. Our talking today is that political actor. You cannot insulate the court from it, and the court is as much part of this overall ecosystem as we are. Court is as much aware of what is happening as we are. The court has to be as much alive to it, and because a court is part of the governmental structure. As far as the law is concerned, what the course the law is to take is basically shape the society. So the courts have to intervene as they are intervening now to correct what may seem to be wrong, so as to address issues which create unrest. Now there will be an element of unrest, and you find there is overuse or overkill. Where else will you deal with it except through a mechanism of the court? I have absolutely no issue with the court dealing it this way. All I am saying is, it behoves the court, and definitely a Supreme Court, when it deals with it in this way, to set the dealing in a surer legal foundation, which I don't feel it having done in the instant case, when the opportunity was there to do it, so that for all times to come, the standards which had to be applied to rein in those who may choose to misapply the law would be clearly set out to preempt any kind of misuse in the future and assure us of a more sound protection against abuse. That is why.
So if we were to list out, there was a Justice Khanvilkar judgment, which was widely criticized for having given too much of part to the investigating agencies. Now there is Justice Gawai, who's trying to bring in some safeguards. Are you seeing? Do we look at this as a resetting, recasting of the constitutional understanding of Section 45, or as you say, this is all pure sentiment? Courts are also hostile to political environment.
I'm not. I mean, let me rephrase. I mean, the way you mentioned, I'm not calling it pure sentiment. I'm saying it's a sentiment which is predominating a process when that has necessarily to be accompanied by a clearer enunciation of law.
How do you put a constitutional mechanism around this?
Yes, now constitution, that's what I'm saying. Now, one, there is a reset, and that reset is warranted and necessary, and that reset is manifest in these orders. And as far as these orders are concerned, the particular cases, in the manner in which the statute has been applied, it would have a justification which is not available to easy criticism, right? But we are not going to deal with individual cases, right? When we are dealing with the Supreme Court, we don't deal with individuals or individual cases. When you deal with the Supreme Court or courts for that matter, we deal with norms, right? It is norms which make the society, right? Now, if we are going to discuss, like if all these judgments are available to multiple interpretations and you can find loopholes and differences in each one of them, then in a new situation which will arise later, where the willingness to intervene may not be that pronounced, there will be an easy option not to follow them. When there is an option not to follow, that means law is not certain. And if law is not certain, the protection is not assured. And for any polity to guarantee to a commoner due security constitutionally mandated, the protection has to be sure and clear.
Okay. Lastly, how do you respond to this constant sort of clarion call which is coming from the topmost court of the country? Right to liberty is sacrosanct. Right to freedom is sacrosanct. Bail is the rule, jail should be the exception. And on multiple occasions, the Supreme Court is expressing its disapproval of the manner in which proceedings are taking place in high courts. Tell me, you've been a legal mind for so long now. How do you respond to this rift, should I use the word, between high courts and Supreme Court?
No, I would call it's not unusual for the Supreme Court to comment on what the High Court has done. I won't call it a rift at all. Supreme Court, in a constitutional sense, is authorized to comment on what the High Court has done and point out aspects of it where it feels that the High Court is wrong. What the High Court is doing has done in these particular cases, and in Sisodia's case, this is what Justice Gawai pointed out. In the first order which he had passed, he had mentioned two aspects. One is the merits, the other is the delay. And what he flagged was the fact that the question of delay was not dealt with properly, right? So, to that extent, that issue was in some way commented. Anything? That issue was not. So, I would not question here is, you first mentioned the importance of 21. 21 has always been important, right? But 21, when you talk about 21, liberty is the procedure. Procedures in laws. It comes back to my favorite thing, procedures in laws. So, when the Supreme Court deals with 21 and correctly says it is sacrosanct, in that event, to do a complete job of 21, while dealing with the substantive aspect of 21, reinforcing how sacrosanct the liberty is, also deal with the procedure, as I just pointed out, and explain how 45 is inappropriate and in what way can the delay which it has flagged be set in a notion which is clear to apply it across all cases which follow.
All right, Mr. Lekhi, great pleasure for us to have got all these clarifications from you. I hear from you very clearly that it's time perhaps for the courts of the country to decide what is the outer limit or an acceptable limit of this incarceration minus a trial. I mean, that's a long way in some way. And how to provide a constitutional mandate around what you describe as sentiment. Great pleasure for us to be in conversation with you. Thanks so much.